very much, and thank you for the invitation. I'll speak in English. What I want to do today is make the argument that the legal foundation for academic freedom in Canada is relatively unique compared to other places in the world. In the United States, academic freedom is largely protected by the First Amendment of the Constitution. In a famous court decision, academic freedom was seen as a special concern as the First Amendment. In the European Union, academic freedom is grounded in the Charter of Fundamental Rights. Individual countries such as Greece, Germany, South Africa, the Philippines protect academic freedom explicitly in their national constitutions. The United Kingdom, Australia, New Zealand, and recently, as my colleague Lucy will discuss, here in Quebec, there's specific legislation on academic freedom. Outside of Quebec, there is no legislation in Canada on academic freedom. There's no constitutional protection. It doesn't exist in those formal channels of law. Academic freedom is not found in legislation outside of Quebec. The Supreme Court of Canada has determined in a famous case in 1990 that the Charter of Rights and Freedoms does not apply to universities, so we don't have that constitutional protection either. Provincial human rights tribunals have only occasionally considered issues of academic freedom. So academic freedom in Canada is primarily a negotiated right, a contract right, embedded in contract law and grounded in collective agreements. I want to just give before I step into things a bit more, I want to give a general sense of how I see the state of academic freedom in Canada today. We heard some earlier presentations this morning about the state of academic freedom in different jurisdictions. But I'd say that a lot of the cases I'll talk about are individual cases. But I would want to make the argument, and maybe a bit controversially, that the major threat to academic freedom today is coming from changes in the labor force itself. That is the rise of contractual labor. Given that 40%, 33 to 40% of people who teach in universities today are off the tenure track, do not have tenure. That's a significant threat to academic freedom because tenure is the procedural protection for academic freedom. So I want to just put that aside, but to say it's really important because that's the structural threat to academic freedom that we're facing. A lot of the cases I'll talk about are more individual instances of alleged violations of academic freedom. But overall, I'd say that contract or labor law in Canada has generally been, or is generally given strong protections for academic freedom. Because, this is where it may not be applicable in other jurisdictions, because one, the unionization rate of faculty in Canada is very high. Over 85% of people who, of faculty, of professors are members of a union. There's only a few institutions left that are non-unionized. I would argue even though they're non-unionized, they still have a collective agreement, they still have a grievance process. They're still, for all intents and purposes, like a union. So we have one very high unionization rates. That's important because that means faculty unions then have the resources to litigate cases that individuals wouldn't have on their own. And Canada's system of binding labor arbitration, labor tribunals, has produced fairly robust decisions on academic freedom with a couple of, I think, important exceptions, which I'll talk about in a moment. At the same time, I'd say there are limitations to embedding or seeing academic freedom embedded in contract law. Contractual protections for academic freedom obviously only cover members of a bargaining unit, only those who are covered by the contract. Those outside the contract do not have that legal protection. And some elements of labor law, such as the duty of loyalty, which is part of the Quebec Civil Code, it's an implied obligation in English common law, but the duty of loyalty, I would argue, also conflicts with principles of academic freedom, particularly when it comes to the freedom to criticize your institution, the freedom essentially to criticize your employer. And we'll see that that's led to some inconsistent arbitration decisions. And I'd also make the case that for labor arbitrators, intramural, that is the ability to criticize your institution, and extramural speech that we heard about this morning, the ability to comment on matters of public affairs, those two elements of academic freedom remain poorly understood. All the cases that we see around teaching and research, academic freedom and teaching and research, arbitrators have a pretty solid understanding of what that means. When it comes to these other elements, we get mixed decisions. So what did academic freedom in Canada look like before unionization? I would argue it largely didn't exist. At least it didn't have any real contractual or legal force behind it. Prior to certification, academic staff had few actionable rights. Litigation was often unsuccessful. Normative institutional policies, so an institution's policies on academic freedom had no legal standing. Institutions had wonderful policies on academic freedom, but there was no way to enforce them. The Canadian Association of University Teachers, which was founded in 1951, founded here in Montreal, by the way, would investigate alleged violations of academic freedom and try to persuade and pressure administrations to rectify matters, but there was no legal stick to wield. We were successful occasionally. In the case of, in 1958, probably the most famous founding case of academic freedom in Canada, the dismissal of Professor Harry Crow at United College, which is now the University of Winnipeg. CAUT managed to, it was an investigation led by Bora Laskin, who went on to become Chief Justice of the Supreme Court, that found that there had been violations of academic freedom and due process in the dismissal of Harry Crow, and he was eventually reinstated. But in other cases, we were not successful. The termination of Norman Strax at the University of New Brunswick was not reversed, despite the fact that CAT imposed censure on the university. In 1966, Queen's University law professor Daniel Soberman reported or produced a report for CAUT that concluded there was no legal recognition for tenure or academic freedom in the Canadian courts. And he went through all the decisions involving dismissals of academics up until that time and found there was no legal foundation for it. And he had recommended the possibility of considering what industrial unions do, and that is certify with a collective agreement, which in 1966 was considered a bit of a radical proposal. In 1970, the Supreme Court of British Columbia saw a case involving a dismissal of a professor at Simon Fraser University. So the association was not, there was a faculty association, but it was not certified. The Board of Governors had accepted a policy statement on academic freedom that the association had proposed. When Professor Wheeldon was fired after she had protested department procedures and joined a departmental strike, she contested her dismissal, and the matter went to the BC Supreme Court, which determined that the Board of Governors did not intend that any legal consequences should flow from the statement on academic freedom it had adopted. So they concluded that it was not a violation of academic freedom because academic freedom had no legal standing. So that had, by that time, that had pretty much convinced a lot of associations that the only possibility for legal protections for academic freedom was in contract law. And the very first academic staff association that certified was here in Quebec at Sherbrooke, the Engineers, in 1970. And within about 15 years, about 50% of all the faculty associations across Canada had certified. Now, as I said earlier, it's probably 95% of the faculty associations, representing close to 90% of all faculty. And as such, all academic or all collective agreements between academic unions and universities have language on academic freedom, and it's all pretty consistent across the country. So almost all collective agreements define academic freedom as having four components, and these four components come from a long history of the development of academic freedom, an understanding of it that has roots in Germany, in continental Europe, in the UK, and in the United States. But basically, I often describe these four components as the four legs of a chair, that they're all indivisible. If you pull one leg out, the whole chair becomes unstable. So the collective agreements define academic freedom as the freedom to teach and discuss, freedom to research and publish your work, freedom to engage in service to the institution and express one's opinion about the institution or the system in which you work. That's the intramural academic freedom. And freedom to express one's opinions on matters of general public interest. That's the extramural academic freedom. So on the issue of freedom to teach, and I want to go through now some labor arbitration decisions. This is the major jurisprudence we have around the understanding of academic freedom. When it comes to freedom to teach, the language in collective agreements has protected professors where claims of discrimination were brought by students about lecture content and assignment of topics. In a case at the University of Ottawa from 2020, it was found that expression and communication made in the context of the exploration of ideas, no matter how controversial or provocative those ideas may be, are protected by academic freedom. And this was a case in which a grievance was upheld against actions by the administration against a member. At Seneca College in 2020 as well, the arbitrator found that the professors have a right to academic freedom, which includes expression of critical opinion of academic work and a challenge to the content of an academic paper. This involved some professors who had engaged in harsh criticism of a colleague's paper, and the colleagues thought that that constituted discrimination. And the arbitrator said, no, that's part of the rough and tumble world of academic expression. In the University of Saskatchewan, a case from 2017, a very interesting one where this involved a contract professor, so not someone with tenure, who in the course of a lecture about Indigenous rights in Saskatchewan had made some comments that one student felt was inappropriate. That student filed a complaint. The professor was terminated. The arbitrator overturned the termination based on the following, saying that in a university or college, one would expect provocative and sometimes argumentative discussions between an instructor and students. And so this was to be expected. So upheld the grievance and ordered reinstatement of the professor. On the other hand, I think arbitrators have been very clear about where the limits are in terms of freedom to teach and discuss. It has not protected professors who deviate from policies or their professional responsibilities. This seems almost obvious, but I think it's important that arbitrators have turned their minds to the limits of academic freedom. So in one case at the University of Ottawa, a very complicated case involving a professor who offered to provide students all with a minimum A grade, I think it was, or a B+ grade if they simply showed up. Didn't have to do any work, just had to show up. And then he would give you, so there's no way you could fail the course as long as you showed up. And then deviated from the content of the course itself, kind of refashioned what the course was about. The arbitrator in that case found that the administration's imposition of discipline was justified, saying that academic freedom is not so wide as to shield a professor from actions or behavior that cannot be construed as reasonable exercise of their responsibilities in an academic setting, nor does it protect a professor when exercising academic freedom in contravention of the provisions of the collective agreement in general. So that what in that case, the arbitrator argued was that the responsibilities clause of the collective agreement was in violation here, so the professor was not living up to their responsibilities. There was a case in 2003 at Memorial University where the Faculty Association had filed a grievance over mandatory course evaluations. Probably one of the least popular things that I can talk with my members about is student evaluations. It riles people up. The administration or the union argued that the course evaluations were discriminatory and shouldn't be accepted and should not be used should only be used for or shouldn't be used for major career decisions. The arbitrator rejected the association's grievance, saying it's hard to see how mandatory course evaluations would interfere with a faculty member's right to teach without deference to prescribed doctrine. And there was also a case from the University of Regina that it was not a violation of academic freedom for a department head to insist on the inclusion of a basic introductory text in 2 sections of a course. So arbitrators have I think, developed a fairly sophisticated understanding of what academic freedom in teaching entails. When it comes to freedom to research, there's actually very few cases around this. But the cases that have arisen is that arbitrators have determined, or labor arbitration boards have determined, that freedom to research protects research confidentiality, very important for people who are doing research involving human subjects. It also protects the right to publish or not to publish your research. There's the Quebec courts in a very famous case in 2014 that dealt with an RCMP, the police request that documents involving research be turned over. The researchers, with the support of CAT, pushed back against that, arguing it was a violation of research confidentiality. The court sided with us and said that academic freedom is of great importance when the work product of university researchers was obtained and or created and could only have been obtained and or created through a promise of confidentiality, and denied the request for the research materials to be turned over. There's also a case from the University of Montreal in 2018 where someone had been hired by, a professor had been hired by a hospital to produce a report. Produced the report, and the hospital tried to change some of the conclusions, so he refused to put his name on it and had to go to court to enforce that. And the court found that it's inconceivable to force a scientist to finalize the writing of an article or to present research results which they do not believe or which they do not share, or according to the methods imposed by a third party. However, much like with academic freedom in teaching, when it comes to academic freedom in research, arbitrators have also found that it's not so broad as to protect fraudulent activity. You can't make up research data and say it's my academic freedom. Nor does it impose a positive obligation on the institution to provide a venue for the publication or communication of research. At the University of Windsor, there was an interesting case where a professor was found to have violated basic research ethics and had actually made up data. And the arbitrator was very clear. Tenure is intended to protect faculty members from many types of infringement upon their capacity to carry out their academic functions. It's not designed to shelter them from the consequences of a serious fraudulent conduct. When it comes to intramural academic freedom, there again have been very few cases. It's sometimes been used to protect professors who publicly criticize their institutions. A case from Caribou College, which is now Thompson Rivers University in Kamloops, British Columbia, is an interesting one where a faculty member had engaged in pretty vociferous criticism of the administration and of the college itself, referring to it at one point as a glorified high school, as that the degrees are worthless, pretty harsh stuff, and was eventually terminated. As the union appealed and filed a grievance, the arbitrator overturned termination and said, much to his surprise, he said, the college faculty have felt and exercised a surprising degree of freedom to publicly badger their employer. Until the events which eventually resulted in this hearing, that sense of freedom has gone utterly unchecked by the college. So he argued that this was not consistent with past practice and ordered reinstatement. York University, a case involving a professor who had published a pamphlet that was critical of the university administration and a fundraising wing of the administration, that led the university to publish a statement condemning the professor and accusing him of being racist, of being anti-Semitic. In that case, the arbitrator upheld the grievance and found that the university's action had violated his academic freedom, and said the implied accusations of racism and bigotry and the implicit suggestion that no student should be exposed to this kind of material, which the professor has produced, were a clear violation of his academic freedom. On the other hand, there's been other cases in which professors who've criticized their administrations were found to have crossed a line by arbitrators. One of the more, I find this one a very troubling decision. It comes from the University of Saskatchewan in 2015, where university library staff and librarians, particularly outside of Quebec, are considered faculty and have academic freedom. University library staff were reprimanded after they criticized the head librarian when she was trying to defend layoffs that were being imposed on the library. And the arbitrator here found that, yes, they had a right to criticize, but it was really the way in which they did it. It was impolite, and found that academic freedom must be exercised in a collegial setting. And I think in this case, the arbitrator is misreading the sense of what is collegial. Collegial refers to shared governance, not congenial, right? And that academic freedom must be interpreted in the context of the rules that govern civil society generally. That is, you have to be nice to each other. And he said there's a subtle but important distinction between exercising one's right to criticizing and calling someone to account. I find this a very loose definition of what constitutes civil discourse, because it applied to the previous case I mentioned, the case at York, I think the university could have argued that the pamphlet produced was very uncivil, or that in the case of Caribou College, the professor's criticisms were pretty harsh towards the university, and I think very impolite and controversial, but the arbitrators there employed a different standard. At Bishop's University, also a very difficult case there, where a faculty member who was also president of the union had criticized the board for a decision, and the arbitrator in that case found that the criticism must be expressed, however, must respect the rule of law and be exercised in a nonviolent and responsible manner, and found that it was not that the professor was not acting responsibly when criticizing publicly the board. She should have done it privately. Again, I'm not so sure about that. When it comes to extramural academic freedom, I think the main issue here is arbitrators often rely upon traditional notions of the duty of loyalty. Is that any criticism of the institution or things that you say outside the institution that brings a reputational damage to the institution essentially abrogates your duty of loyalty to your employer. And this is one where I think we needed to do a lot of work with arbitrators in expanding upon. So my general conclusions are that intramural and extramural academic freedom, as protected in contract law, are the weak links in the case law, with inconsistent approaches being taken by arbitrators. The question I would pose is, could the application of the charter, if it was determined that the charter does apply, the Charter of Rights and Freedoms applies to universities, would that better protect intramural and extramural academic freedom? The university is a workplace, but it's a workplace of a special nature because of academic freedom. I think this element is not fully or well understood by all labor arbitrators, who often fall back on, as I mentioned, the implied duty of loyalty in rendering decisions. So I think we need to find ways of doing more education of arbitrators and develop more case law to shore up the protections, particularly for intramural and extramural academic freedom. Thank you.